Let us in this chapter understand the taxation of interest. Now, what can happen is, suppose there's an Indian company, okay? It may take certain funds from a non-resident. This could be, by way of a loan, right? Which could be from a shareholder or from a bank. It could be some form of convertible instrument like compulsorily convertible debentures, which carry a coupon rate. Even unconvertible or non-convertible debentures, where interest is payable, may be getting covered over here. So how would the taxation work in the hands of the non-resident, right? Whether it is India or it is the state where this non-resident is a resident that has a right to tax, right? Is there any withholding tax which has to be applied in India? All these questions are something which is governed by Article 11, interest. And then the most important question, what exactly is interest? What is covered over here? That is something which is dealt with in Article 11 of most of the treaties, and which is what we are going to look at as a part of this chapter. So as you talk about interest, there could be two situations which can arise. There could be an Indian company which makes a payment of interest to a non-resident. We've taken that as F1, FCO, whatever it might be. The issue comes here is whether this is taxable in India. It's not necessary that in all the cases it might be taxable in India, but it may be taxable in India, which means that India, under certain conditions or circumstances, may have a right to tax such interest payment. Another situation could be that there is an Indian company which is owned by a foreign company. Now, in a third state, there's another company or a person X which is making payment of some interest to F1. Now, obviously, between ICO and F1, there is no transaction. So this provision or this interest which is getting paid here is not a subject matter of being covered under Article 11. The next thing is that if there is a PE which this foreign company F1 has in some third state, right? If there is some interest payment which is made by F1 which is attributable to the operations of the PE, then also it is not something which is taxable in India. So Article 11 is not applicable to the interest paid in third contracting state, which is by X, right? Or to a PE of F1 in other state, right? So even if F1 were to pay some amount of interest in this particular country, in the state of residence, which is attributable to the PE, it will not be something which will be covered as a part of Article 11. So what are some of the key components, some of the key aspects which impact or which are to be considered or which are to be answered when we look at the taxation of interest under Article 11? The first one is, what is the right of state of residence to tax such interest? So let's say if I am talking about the India-US treaty, what is the right which US has in case a company is a tax resident of US to tax the interest which is paid by an Indian company to a US resident? Now obviously, what is also the right of India or the source state to tax such interest? And what is covered under interest? Or what is excluded from interest? Because if something is not covered or if something is excluded from the definition of interest, then all this becomes meaningless, right? If there is a PE in India which the non-resident who derives interest income has, is it going to impact the taxation of interest? I mean, will it be taxable under Article 11 or will it be taxable under Article 7? Source of interest. That is important. And whether the interest which has been paid is at an arm's length or not. Why this is relevant is that if the interest paid is more than arm's length, then the deduction of the Indian company is restricted. At the same time, most of the treaties also provide that if what is derived is more than arm's length, than the excess. So let's say someone were to receive an arm's length interest of $10. He gets not 10 but $12 as income. The excess $2 in this case is something which is not going to be taxed under Article 11, but it will be taxable either as business income or other income depending on the facts of a particular case. Now, while we spoke about the taxation of interest in the hands of the recipient, equally important is the deduction which is allowed to the company which is making a payment of interest, right? In some cases, the local provision of the source state may include different provision for taxation where a payment is due or is made to a resident vis-a-vis a case where it is due or paid to a non-resident. So if you look at this, we have an Indian company which is making an interest payment to MCO. All this is currently happening in the source state, which is India. In the state of residence, the same ICO is also making a payment or is having an interest which is due to a foreign company. For consistency, let's say both the interests are actually due and none of them has been paid. What if interest due to the foreign company is not allowed, but the interest due to the MCO, which is an Indian company, is allowed? Why? Because the interest to FCO has not been paid. In such a case, one can actually go and claim the benefit of the provision relating to non-discrimination, right? And the allowance may be claimed by ICO for interest paid to FCO also, right? Even if the payment has not been made, even if it is due, if there's a differential tax treatment just because of the residence. Here, MCO is an Indian resident, FCO is a foreign resident. If there are conditions on non-deduction which are different or adverse for a non-resident, they can go and claim the benefit of the non-discrimination clause in the treaty to claim a deduction based on the same principles which are applied to a resident. So as we move along with this presentation, what are the key issues which one should analyze? Suppose there's an investor who's given a debt to an Indian company and the Indian company makes a payment or accrues interest, right? The issues which you should know is whether this interest will be taxable only in the source state, which is here, or only in the state of residence, or both the source state and the state of residence. What is interest, right? And then whether only interest paid should be taxed in the hands of the investor, or even the interest remaining unpaid should be taxed. All these are something which we are going to see as a part of Article 11.